primary case as to the issue is out of the 4th District Court of Appeal in the Muhlenberg case. And that specifically addressed the question as to the element of impairment. The defendant in that case had a blood alcohol level less than the legal limit. He had asked for an attempted DUI instruction. And when it went up on appeal, the court ruled, no, you can't have attempted impairment because that would penalize innocent conduct. But the question remains open as to the other primary element of driving under the influence, driving or being in actual physical control of the vehicle.
You know, the facts were that this man had been drinking in a bar and came out to the parking lot and was fumbling with his car keys trying to get in to the driver's side door of the car to drive home. See, maybe that might be an attempt at DUI, but you've got a man who is sitting in the driver's seat with not only the keys in the ignition, but the engine running, and in a location that's, I don't know how many miles, but miles from where it was he said that he was drinking when he was talking to the police officer. Why isn't that enough to be a completed and only a completed DUI?
Your Honor, I would argue that that would be sufficient to defeat a motion to dismiss, and that would be sufficient to defeat a motion for judgment of acquittal. But it is not sufficient to say that there is no view of evidence that the fact finder, that the jury could have taken with respect to these facts.
But he's in undisputed, he's in possession, he's the only person in this car, right?
That is correct, Your Honor.
So he's in possession and control of a motor vehicle that's got the engine running, and he's intoxicated. I mean, you don't actually have to be an operator, you merely have to be in control of the vehicle for this crime, right?
Your Honor, if the legislature had intended that, then the crime would be physical control. It does seem to me that the word actual is an important modifier with respect to physical control. Now, the legislature has not defined actual physical control. They've left that to the courts to determine. And so some of the courts have focused on the word capability. Did the defendant have the capability presently to operate the vehicle? It's my contention that you could take different views of that definition of capability, and that it should have been something that we allow the jury to determine. If it was ambiguous as to whether this necessarily constitutes actual physical control, then it's my position that the rule of lenity applies, and that means if there are differing constructions that we can bring to the statutes, we have to adopt the one that's most favorable to the defendant. And that, as I pointed out in the brief, was particularly important to Mr. Bryant, because had the jury taken the view of these facts that this was attempted DUI, Mr. Bryant would not have ended up as a convicted felon and would not have had the other mandatory penalties associated with felony DUI. When I look at the crime of attempt under Florida law, I see no reason why this could not be attempted DUI. The attempt statute appears to apply to all criminal offenses in the state of Florida, except when it is part of the offense itself, like the crime of theft, or when it's clear, for instance, in a murder prosecution, that if the victim is dead, then only could we have a completed offense, no possibility that we could have had an attempt in that situation.
What would be the act that your client was attempting to do but had not yet done?
Attempting to have the capability to control the vehicle. And that's where there is ambiguity, and that is where the fact finder comes in to determine whether the state has proven that offense. So there's one other aspect to Mr. Bryant's appeal, and that is that he was sentenced to prison on this charge, despite the fact that he scored out less than the points established by the statute. And we brought the motion to correct illegal sentence, and upon the resentencing hearing, he was again sentenced to prison. At the time that that was going on, there was another case named Bryant that was pending before the Florida Supreme Court.
Not the same man, I hope.
Not the same person. And that case has now been decided. It was actually decided after the initial brief in this case was filed. But I have two arguments about that. First, since the trial judge did not contemporaneously impose a written finding of a danger to the community, that Mr. Bryant should not have been sentenced to prison. And then secondly, his subsequent findings of fact covered only things that were inherent in the offense. There's nothing in those findings of fact that show why Mr. Bryant was some particular danger to the community. It simply focuses on the elements of felony DUI. So even though at this point in time it doesn't necessarily do Mr. Bryant any good, because Mr. Bryant has served his sentence and is in fact present in the courtroom for these arguments this morning, it is still an important principle to clarify, not only for his case but for other cases. And I think it's the kind of situation that may elude review unless it is addressed by this court today. So with that, if there's no other questions, I'll reserve the balance of my time for rebuttal. Thank you.
We'll hear from the state.
May it please the court, Dawn Tiffin representing the state of Florida. With regard to opposing counsel's assertion that this case involves a question of whether the offense of attempted DUI actually exists, the state respectfully disagrees. It does exist. It will be a much less common factual scenario with regard to a theory of actual physical control, but it is certainly in existence. However, the question in this case is very simply, did the evidence support the giving of the attempted instruction in this case? The answer is no. All of the evidence proved only the completed offense under an actual physical control theory. Now, there was a lot of discussion about this on the record below, quite lengthy, but the conclusion was, logically and rightfully so, that the state was proceeding only on an actual physical control case. There was no evidence of driving. The state was not going to argue that in closing, in opening, or any other point in the trial. So they had to proceed on what the evidence was, that the defendant was found in the car with it running, with the keys in the ignition. All of the facts established that not only could he have the capability, he did. Again, it was a completed offense.
Does it make any difference that he was asleep?
No, not from the state's position.
Well, if it's a control case, how do you control anything physical if you're asleep?
Well, when he was asked to turn off the ignition, when the officer arrived, he was able to do so.
Well, that's because the officer woke him up, right?
The officer did wake him up, but it's still established that the elements.
3 times to wake him up?
I'm sorry?
Took 3 times to wake him up?
That sounds right. It was a couple of times to rouse him by the officer. But the elements of the offense don't indicate that the actual physical control has to happen at any particular time frame. It's just actual physical control when the defendant is under the influence of alcohol. So, but the fact that he had the car already running the state's position is that even having the keys in the ignition, even having the keys in his pocket would have been sufficient to establish this offense. Here we had a lot more, and this is not a JOA issue, so pardon me for going a little bit in that direction, but there was even more evidence in this case showing that he certainly had the capability because he was operating it. Whether he was asleep or not, he had the car running, the lights were on, and that is a completed offense of DUI with actual physical control. So again, lengthy discussion on the record. The trial court looked at it every which way that it possibly could and rightfully determined that the evidence just did not support the instruction of attempt in this case. Would it apply in another case? Sure, but not with this evidence, not under these facts. With regard to the sentencing issue, I think...
What would the attempt look like? Would it be, as Judge Altenburn suggested, if he's intoxicated, he can't get the key in the door to open the door or something along those lines? Is that what that would look like?
I think that would be a fair factual scenario to support an attempt instruction. Again, actual physical control means being in or on the vehicle, so the attempt could come when someone's trying to get in the car, on the motorcycle, depending on what the particular vehicle is, while inebriated. Certainly that could happen. It's just not the most common set of facts that we deal with in actual physical control cases, but certainly it could happen, especially when alcohol is involved. You know, there's really no limits to what people can do in those situations. So, but unfortunately for the defendant, this just was not that case.
Operationally, does the physical control actually serve as an attempt?
I'm sorry, I didn't hear the first part.
The operation of the statute says driving or actual physical control, and as you pointed out, I think there's a case Judge Northcott authored, Fitzgerald, if you have the keys in your pocket in your hot seats, that's a physical control. Isn't that actual physical control basically an attempt? And so you're really having, if somebody's trying to put the keys in an attempt to commit an attempt, because operationally the actual physical control is not driving the vehicle, it's just having the capability to drive it. So it's almost operationally like an attempt, or it's at least similar. It's not exactly like, forgive me, I'm not saying it's exactly like.
I don't agree, and here's why. Because in that case, there was no, and there would be no attempt to actually put the gear in drive, to actually move the vehicle. There is a distinction when we're talking about DUI offenses in this driving versus actual physical control. There's attempt in these factual theories about operating the vehicle, which could be running it, sitting still, which is what we had in this case,
Could be in park, could be in
and then
neutral,
moving it. So
could be in drive with the brake on.
Sure.
If a fellow drinks too much at the bar and decides that what he really needs to do is just go out to the car and sleep this off. So he goes out and crawls, even in the driver's seat, and falls asleep because his intent is to sleep this off because he doesn't want to drive drunk. Is he committing DUI?
He is. And many people have been convicted under those factual circumstances because of the way that the offense reads in the statute. That would be, excuse me, that would be driving under the influence, but it would be an actual physical control case. So should that person be found by law enforcement, and should the state attorney's office choose to prosecute it, certainly that would be enough evidence for a prima facie case to prosecute, yeah. It's unfortunate for the defendants in those cases where the intent is...
There's no mens rea at that point in time, none.
But that is what the legislature has decided. Don't even go there. Don't even get in the car with your keys. Maybe if the defendant in one of those cases was in the back seat, maybe that wouldn't be enough to prosecute. But again, these are just very factually intensive cases.
Okay.
All right, well, moving on to sentencing. I do want to talk a little bit about the Bryant case. Obviously, this allegation as to the prison sentence here and the written findings is moot. The prison term has already been completed, and it was completed, I believe, a mere 2 months after the 3800.
Well, it's certainly capable of repetition. Was there an error here?
There was no error. And I don't disagree that it's capable of repetition, but because there's no merit to it, this court really should not consider it. And let me explain why. The Bryant case, the Florida Supreme Court case, dealt with a very specific issue, and that is whether the failure to enter written findings twice, once at the original sentencing and then in response to a 3800B2 motion, was error. That's not the case that we have here. The trial court in this case did enter written findings in response to the 3800. So even though it's in our brief, I do want to read the question in Bryant just for sake of emphasis. The question was whether a trial court may impose a sentence that departs from the CPC on remand where the trial judge failed to comply with the requirements of Section 775.08210, mandating the filing of written findings both at the original sentencing and in response to the defendant's Rule 3800B2 motion. That's taken directly from the case. And again, that's not what happened here. And as the state indicated in its briefing...
Refresh me, with the findings here were made on a B2 motion?
Correct, correct. And that is the remedy that has been left open by the Florida Supreme Court in Bryant because they approved of Goldberg. And Goldberg specifically said that this could have been remedied in that case, in the 5th DCA case, had the trial judge made the written findings in response to that motion. It didn't do that in Goldberg, and it didn't do that in Bryant, apparently for different reasons. But either way, both of those cases went up there with written findings having never been made, despite having 2 opportunities by the trial court to do so. That is not what happened here. The trial court failed to make written findings initially, that's true, there's no dispute about that. But then when faced with the 3800B2 motion, it did make the written findings. So for that reason alone, Bryant just simply does not apply. And I think that's made very clear by the question that it answered by its own admission. I'm happy to talk about drug offender probation, that issue that was raised in the initial brief, if the court has any questions on it. I know that opposing counsel didn't discuss it while he was up, so if there aren't any questions, then I'll simply rely on this.
The drug offender probation is filed in 94820.
Yes.
And most of the times, the statute, I think, deals with terms of 893, which is the drugs. Conceitedly, the statute is written broad enough that that second portion of it could say apply to DUI. But when one looks at the context of the statute, subparagraph 1 talks about because criminal conduct is a violation of 893 or other nonviolent felony. I think that's the key part. But if you look at the definitional section of that chapter, everything purports to suggest that this drug offender policy, including the definitions, is to put somebody on a road to particular recovery. It doesn't reference 316. Now, is this what the legislature intended to the scope to be broadened? Drug offender probation cites 893, and now a trial court is saying, well, I'm going to use it for a 316 offense.
I think by its plain language, it certainly did. I do want to mention, I know this court is already aware of it, based on the state's briefing, this is not a preserved issue. So I want to obviously put that out there for the record today. But if the court were to consider it anyway, I think that the plain language of the statute, by very specifically saying, or other non-violent felony, I think that was intentional, that was purposeful language, so that it would be broad enough to encompass other offenses, including Chapter 316.
Let me play devil's advocate for you a moment, because I also consider what you said, but it seems like the reading of the statute would be that if you have a drug offense that leads you to other non-violent offenders, burglary. You know how many cases the state prosecutes when somebody says, I was burglarizing, I was, stealing the car, non-violent. Would have a that's great, would have a stronger nexus to the title, to the chapter, to the reference of 893 than merely saying this encompasses all forms of probation, because now this probation would seem to swallow up every other provision for probation. It has to be as non-violent, right?
Well, that's an interesting theory.
I understand your argument's not preserved,
right.
But, as I played with this a little bit.
Right. Candidly, I think that's probably reading into it a little too much for this, for these purposes. Because again, the way that the legislature appears to operate when composing these statutes is to leave it either intentionally limited or intentionally broad. So.
But if you link it to the definition of drug offender probation, was that .001 sub 5? Talks about a form of intensive supervision that emphasizes treatment of drug offenders, not alcohol offenders, but says drug offenders. So that was part of my concern, that this statute, if you take the definitional, put it together, this is meant to be a drug offense or an offense that's nonviolent caused by the use of drugs. that would trigger the application of this probation.
Well, and I think that possibly inclusive in the definition of drugs would also be alcohol. When we're talking about drugs, it's really a generic term for substances, that can be abused and are abused criminally.
Well, that's a good point, except they only specifically mentioned one statute in the first part of the statute, and that's 893.
Right.
Because I looked to see if they had 316 anywhere in there.
Right. Now, I certainly understand the court's perspective on that. It's not illogical, certainly. But again, the state is relying on the plain language of the statute and the way that the legislature operates when it writes these things, keeping it broad intentionally so that it can prosecute these offenses when need be. I think that's really where we're at this point. Again, and because it wasn't preserved, this wasn't something that was really developed down below. So we don't have the benefit of the trial court's thoughts on this, or the state's, or the defendants for that matter below. If there are no other questions, we would ask to affirm the trial court's rulings. Thank you.
Thank you. Mr. Tabridge?
I would respectfully disagree that the drug offender probation issue was not preserved. Ms. Mack, down below the trial counsel, had this basic discussion with the trial judge and argued that drug offender probation was limited to 893 offenses. And the trial court actually specifically addressed that argument in his resentencing order. So I just wanted to respond to the preservation argument.
Practical matter, if the drug offender probation pursuant to statute does not apply to DUI, then this would be an illegal sentence. And that may not necessarily require the same type of preservation. So.
That's true as well, Your Honor. However, I do want to get back again just briefly to the attempt argument, because it is the position of the state of Florida here that these facts conclusively establish actual physical control. And I think that the most helpful case that I would like the court to consider on that point is the one out of the 3rd District from 1988, the Feiselman case. And that court said, "We point out that the evidence that the key was in the ignition does not inexorably lead to the conclusion that the defendant was in actual physical control of the vehicle. It is merely a fact, along with his presence asleep and intoxicated in the vehicle, which is capable of establishing actual physical control." The reason that's important is it's quite clear that the theory of defense below was that this should have been an attempted DUI case. And that theory was taken from the defendant when the trial court ultimately ruled that he would not instruct the jury as to attempt. And again, it continues to be our position that that was error. It's understandable error because there's not a lot of case law about this subject matter, but these facts would allow a reasonable jury to conclude that the defendant was guilty of attempted DUI. And therefore, I am asking that the court reverse Mr. Bryant's conviction and remand it back to the 20th Judicial Circuit.
Okay, thank you very much.
Thank you.